Hello friends, in the series on the income tax cases, today we will discuss a very important issue in the case of telephone operators who sells their SIM cards and recharge coupon through distributors. The question before the tribunal was that whatever the margin the distributor gets from the telephone operators on the sale of these SIM cards and recharge coupons, whether this come into the definition of commission and whether TDS should be deducted on commission, which is the margin in this case. This issue has been discussed in the case of Vodafone Idea Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 33 ITR Tribunal Online, page number 74. The matter has been decided by Mumbai ITAT I2 bench and the date of the judgment is 24th February 2023. The facts of the case are like this. In the case, the telephone operator Vodafone Idea Limited was selling SIM cards and recharge coupon to the distributors at discounted price. Generally, the talk time is higher than the discounted price. The whole process includes the telephone operator gives SIM cards to the distributors. Distributors make advance payment to the telephone operator. When distributor get these SIM cards, they sell it to the retailers at some margin, and retailers sell to the customers ultimately in the market. Assessee, who is the telephone operator in the present case, do not make payment to the distributors. The other way is this, that the distributor makes the payment to the telephone operator for purchasing these SIM cards. Income earned by the distributors only when the SIM cards are sold further. There is complete freedom to the distributor in fixing the price of the SIM cards, that is in the range between the discounted price and the maximum retail price. The assessing officer, while making the assessment, was of the opinion that whatever the margin the distributor is getting from the telephone operator, it comes into the definition of commission, and hence the Vodafone Idea Limited should have deducted the TDS on that margin. When this matter was under consideration of the Mumbai tribunal, the tribunal was of the opinion that by reading the agreements between the telephone operator and the distributors, there is no fixed commission which can be determined by these agreements. So, Mumbai ITAT was of the opinion that the TDS mechanism fails because no fixed commission can be determined, and the telephone operator is not making the payment to the distributors, but distributors are getting the margin, and by reducing that margin they are making payment to the telephone operators. So in the present facts and circumstances, whatever the margin the distributors are keeping, it cannot be termed as commission, and there is no need to deduct the TDS by the assessee in the present case. The second issue was that data link transfer and mere interconnection between the operators, whether this come into the definition of fees for technical services. So on this issue, the tribunal was of the opinion that data link transfer and interconnection between operators does not require human interface, does not require human energy, and for terming fees for technical services, it is the essential element that there should be human intervention in providing those services. So, data link transfer and interconnection between operators cannot be termed as fees for technical services. A small issue was that when the matter was before the CIT appeal, the assessee submitted some additional evidence in the form of some agreements, to which the assessing officer objected to be admitted as an additional evidence. And when the matter was before the tribunal, the department was pursuing that additional evidence which was rejected by the revenue. So the tribunal said that because the revenue has not given its permission to admit the additional evidence, so the department or the revenue cannot bank on the same additional evidence which was rejected by the department. Or in other words, tribunal was of the opinion that the revenue could not improve upon the assessment order at the time of appellate proceedings. At the end of this video, once again, I am repeating the name of the case. The name of the case is Vodafone Idea Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 33 ITR Tribunal online at page number 74. The matter has been decided by Mumbai ITAT I2 bench and the date of the judgment is 24th February 2023. Thank you, friends.